most important thing you can do for any form of IP is start a document retention policy, start having procedures in place to protect your IP. If you have a logo that you want to protect, document when you created that logo. Put that somewhere in a file, in a locked file, in some form of protection so you can prove that date up of when you created it. Start using that TM, or if it's a service mark, SM, besides that logo. And start using that in commerce, so when you're dealing with other people, you're using that logo with that TM on there. So you're telling the world, that's my trademark. You're telling the world, that's my logo and no one else can use it. And then after that, you'll want to take that and get with an attorney to formally register.
From humble beginnings, Insurance Claim HQ has grown to one of the largest property casualty firms in the country. We didn't do it alone, and you shouldn't either. Every week, we're talking to claims professionals and top experts from all over, all to help you grow your business and make you stronger. Let's level up together. I'm Galen Hare. Welcome to the Level Up Claims Podcast.
Branding, marketing content, proprietary estimating software, customer lists, specialized restoration methods. I'm talking about intellectual property. How can you protect these vital assets that distinguish you from your competitors? To explore all things IP, we're going to talk to one of the top intellectual property attorneys in the country. Listen up. This is going to be a fascinating but incredibly important conversation. Let's welcome Bill Ramey. Bill, thank you so much for joining us.
Thank you, Galen. It's a pleasure to be here.
So I'm pumped for our conversation. For those of you that don't know, which is probably all of you, Bill and I go way back. We've known each other for a few years now, and he is I consider Bill to be one of the top intellectual property attorneys in the country. So before we jump into that, though, I'd like everyone to get to know you a little bit. So what brought you into intellectual property to begin with?
Thank you for that, Galen, and thank you again for having me here. It's quite a pleasure. I think most IP attorneys get into intellectual property through an odd mechanism because we're all, for the most part, engineers originally, and we were looking for something different. And here, I was working as a process engineer for Air Liquide for a number of years, and just wanted to do something different. And remembered about law school that my faculty professor suggested I look at IP law, at patent law, and so I went to law school solely for the purpose of becoming a patent attorney. And now I have the pleasure of working with inventors and people who are protecting their IP and those that are trying to enforce their IP against those who are infringing it. It's a very exciting profession.
And that makes you such a unique lawyer, in my opinion, because I find that most of us, we go to law school having no clue what we want to do, but maybe thinking we want to do one thing. And then we discover during law school or right after that we hate that thing we want to do. So we end up doing something totally different. You, on the other hand, kind of knew what you wanted to do and actually did it.
I guess there's a second part to that story, though. I went to law school to come out of law school and draft patent applications and sit in that's what I thought I wanted to do. And instead, now I do primarily 98% of my practice is litigation. I find that much more exciting than drafting patent applications. But we have people in the firm here that that's all they do is sit around and draft applications. So
yeah, you guys do patent prosecution, we call it, which is where you actually go get the patent for people. But yeah, as long as I've known you, you've been a litigator. I think at one point, maybe still today, you guys were definitely number one in Texas, but I think number one in the country for infringement suits.
Yeah, thank you for that. We have a mission at Ramey LLP, and that mission is to provide access to the courts for those IP owners, those typically patent owners that typically can't afford a law firm. We try to lower the barrier to entry to filing patent infringement suits. So we in average about 300 suits a year, which is quite a number for patent infringement. And for the past 3-year period, we were the number one filing law firm. We have lowered our level a little bit. I think we're number 2 right now in the total filings, but we don't file cases to be number 1 in the number of cases filed. We try to file quality cases and represent as many different IP owners as we can in asserting their IP and protecting their innovation.
Absolutely. All right, so let's talk about this a little bit. So patents are for inventions. I know that, and because I'm not an intellectual property lawyer. Most of our audience today that are sitting at home listening or driving, wherever they are, They are contractors, they're public adjusters. Some of them might have some inventions, many of them don't. But I do know what they do have, which is they all have like business names, they all have logos. So talk to us about kind of what the world looks like for them. Like what protections can they get? What kind of things should they be doing?
So what you're talking about, your adjusters, your contractors, their main form of intellectual property protection, there's going to be in copyright and in trademarks. And then there might be some associated trade secrets that go along with that. Every business has trade secrets, and occasionally they'll run across a patent. But primarily they're going to want to protect their original works of authorship, whether that be photographs, whether that be drawings they create in CAD, whether that be the form that they fill out when they're taking an assessment of a property, the form they create. All of that information can be protected through copyright. And they can simply do that by formal registration at the U.S. Copyright Office, but on their own, just by dating and signing at the bottom to preserve when they created that, to begin that process, and then later on formally registering it. Yeah, for trademarks, so a trademark or a service mark, which it's any word or symbol that identifies your good or service and differentiates it from a good or service of another. So every company out there has a trademark. The business name, that could be a trademark. The symbol that they use with that business name, that could be a trademark. The way they put their letterhead together, most likely they have some form of a trademark. And trademark protection is very easy. All they need to start doing is put a little TM and superscript, I guess, right beside the whatever symbol they're using, and that'll give you common law trademark protection. And later on, you can get with an attorney and file for formal registration if you'd like. But the most important thing to do is put that TM to start the common law protection.
That's really cool. So like, to put it in super basic terms, if I own like Acme Roofing, and that's my name, like it's Acme Roofing, and I have some logo that's pretty cool. I don't even know what it looks like. I was going to say it would have like a Roadrunner, but I doubt it, because that would probably be a separate trademark issue. But, I've got this cool logo that I spent all this time designing. Like, what are the things, if I wanted to be careful, if I'm worried about another Acme Roofing showing up in my market or, an adjacent market, like what are the things that I should like functionally, literally, like what would you tell me today to start doing these things? You mentioned putting the TM. What else should I do?
Well, yeah, that's a great question, Gail. And so I think the most important thing you can do for any form of IP is start a document retention policy, start having procedures in place to protect your IP. So in this specific example, if you have a logo that you want to protect, document when you created that logo. Put that somewhere in a file, in a locked file, in some form of protection, so you can prove that date up of when you created it. Start using that TM, or if it's a service mark, SM, besides that logo, and start using that in commerce. So when you're dealing with other people, you're using that logo with that TM on there. So you're telling the world, that's my trademark. Telling the world, that's my logo, and no one else can use it. And then after that, you'll want to take that and get with an attorney to formally register it. But the most important thing is to start putting policies in place to protect those logos and start documenting when you create IP, and then protect it after that.
Now, you mentioned kind of putting that TM, but then later getting with an attorney to register. What does that do? Like, why would I register a trademark?
Okay, that's a good question as well. The main reason you'd register a trademark is so that, one, it becomes a national. If you're only using the TM, you might be only able to get regional rights on it, right? It's because wherever you're marketing to. So if you're advertising locally, for instance, in the New Orleans area, or locally in the Houston area where I am, you might not be able to get rights beyond that Houston area. But if you register it, you're going to get national rights, and you're going to be able to tell the world that that's my trademark. And on top of that, it opens you up to be able to get federal some special damages in any infringement lawsuit if someone's using your trademark that aren't available with a common law trademark.
And we all make this mistake, right? So like, I have no problem admitting, like, we have our name, it's like Insurance Claim HQ. And I saw a lawyer left us, and he opened a law firm called like Claim HQ or something, So of course we like got a local IP lawyer to where we were, because we knew we were going to want to sue him, where we're located. and realized we never registered a trademark, like ever. As a lawyer, it was something I totally overlooked. It didn't kill our case. We still had rights, but what I came to understand is it would make our case much easier. How is it easier if you've registered your trademark?
So again, going back, when you register your trademark, you're establishing that federal registration. So you're preemptively or presumptively you have now nationwide coverage for that trademark, and you're making everyone aware of it. And so you can go into court with that trademark and say you're infringing, and it opens up injunctive relief that's not available with a common law mark. It opens up a greater range of damages, and able to, your attorneys might be more excited because they're able to collect their attorney's fees against the defendant you're suing. It just makes it much easier to protect. Yeah.
Well, and I think that's a big point that we shouldn't overlook, right? Because the contractors and public adjusters at home know this. They know it is way easier to succeed in a bad faith claim because usually the attorney's fees are covered, right? So when there's bad faith, they know that usually it's easier to get the claims covered. So if you're registered under certain circumstances, you might be able to actually get your attorney's fees that you had to spend for getting this person to stop stealing your intellectual property.
Yeah, that's correct. I mean, the most expensive part of almost any lawsuit are the attorney's fees, right? The costs are fairly de minimis compared to what the attorneys charge you. I mean, I know I have a couple of cases that my firm's in. I hate getting the bills from the attorney. I can only imagine what my clients think when they get bills from us, right? So it's the attorney's fees are a big part of it, and that's one of the main reasons why you'd want to federally register your mark.
100%. Yeah, it's crazy, right? To be on the other side of it. We've had a couple of cases over the years, and I get the attorney fee bills, and I kind of moved to this, like, I call it like silent resignation on it, like I know at the end of the day, I've been charging my clients for years, so I know I just kind of have to pay these attorney fee bills. So I got over the like righteous indignation of that bill is insane, right? Now I just pay them. Sometimes I don't even look at them, to be honest, just because it makes more sense. But yeah, it is. It's always the most expensive part. And I think that's why people don't protect their intellectual property to begin with, is they think it's going to cost all this money to protect it, and then they think it's going to cost even more money to actually defend it.
Yes, I think there are some simple things that people listening to this podcast should remember that make it much less expensive to register or protect your IP. Remember, intellectual property shouldn't be something that we all think of as something esoteric. Yeah, it's something that our mind creates, so it's intangible. But IP is just really anything that gives your business a competitive advantage. That's purely what anything IP is. It just gives you a competitive advantage, whether it's a trade secret, something that's not generally known in the industry that you want to keep secret by keeping non-disclosure agreements with the people you're dealing with, by keeping that trade secret limited to those people that need to know it to operate in your business. Keeping the locked cabinets up where you keep that trade secret, marking everything is confidential. When it comes to that trademark we've been talking about, using that TM religiously, and then filing for federal registration, get that registration 6 to 8 months later, and then start using the Circle R on it. So you're telling everyone you're federally registered. Those are simple things that be done. Start an IP policy in your business where you document everything you create, the date that it's created, have someone witness it for you. I mean, those policies like that are just easy things to do on that. Educate your employees by providing them what the current status of the IP law is. Usually it's pretty easy to find an IP attorney that wants to come and talk about that. And so you can educate your employees by calling in an outside IP attorney. It sounds like that's what you've done through these lawsuits.
Oh, yeah, you wouldn't want me doing it. Although I did do intellectual property litigation for a very brief stint of my career. I was mainly more local counsel. I wasn't really the lead lawyer, but I actually represented a bong company of all people.
Well, I think actually, you're local counsel for us in a few lawsuits, I believe.
Yeah, we've done that for you. I don't know if they're still ongoing. I guess one of them is for sure. But yeah, we've done some local counsel for you. But yeah, we actually this bong company out of I want to say the Netherlands. Found out that all these people were like ripping off their bongs and, making counterfeit. So they went through the whole state of Louisiana, went to like every gas station essentially bought counterfeits from every one of them, and then turned around and sued the gas stations and the distributors that were passing off counterfeit bongs. So I learned a lot about drug paraphernalia that I did not know during the process of that claim.
It always works out that way, doesn't it? When we go into a lawsuit, and whatever the subject matter is, we come out knowing more than what our clients do about the subject matter, I think, because we have to get into the details about it and everything.
Oh yeah, it was crazy.
At least that's the way I feel.
It was absolutely insane. Like, I learned literally how the glass was made and why this glass was supposed to be higher quality than like regular glass. And I don't judge anyone that smokes marijuana, but I never thought I would know that level of detail about what makes a good bong versus a bad bong. So if anyone ever needs to know, just hit me up. I will tell you how to identify what a best bong is, but all that comes with a disclaimer that I'm not necessarily a partaker.
Whatever the tempered glass is, right?
Yeah. So let's talk about so if you have registered or you've got these common law rights, like what kind of things should companies be doing to like proactively monitor and make sure they're not getting infringed on?
That's a good thing to know. So I like to think about it. There's 4 main types of IP rights that we kind of talked about today. That your copyrights, your trademarks, your trade secrets, and your patents. Each of those is a different form of intellectual property, and each of them has different consequences if you allow someone else to infringe on those rights. For a copyright infringement, if you know about someone infringing and you wait more than 3 years to file a suit, you'll have no ability to get damages from them. So it's very important that you're proactively monitoring the market to make sure that people aren't infringing on your rights. If you have a trademark that you know someone's infringing on, it is possible that you will not be able to enforce that trademark if you allow too much time to lapse. A federal registration makes that difficult to completely allow a trademark not to be enforced, but it does create issues when enforcing it if you don't enforce it. With a patent, you're limited to 6 years after you learned of the infringement to go back and get damages anyways, but you can always enforce that. And for a trade secret, of course, if someone steals your trade secret and you don't jump on them right away to stop them, you lose the trade secret, because the definition of a trade secret is something that's not generally known in the industry that gives you both an economic and competitive advantage. So if you allow it to become known in the industry without trying to stop it, you're losing your trade secret.
Wow. Yeah, we have a very large trade secret case. It's like the only IP case we really have where we're not local counsel. And that's exactly what happened. It was a small minority-owned business, had developed an app with all these things, and a major, like Fortune 100 company signed an NDA with them in the process of like discussing paying royalties and leasing the product. And after the meeting, just essentially hired developers and said, "We want you to build this," and ripped the entire thing off, coding and everything. So, but part of the issue in this case is timing, because they probably stole the trade secret sometime earlier, but it took a while for the client to find out, because it wasn't until they made a public announcement that they'd created their own version of this product. So it's crazy.
It happens all the time. I don't know if you're noticing the news right now. There's been some articles about Parker Vision versus Qualcomm, and that Parker Vision alleges that their trade secrets were stolen by Qualcomm years ago, when they were in exactly the same situation, trying to work together to learn something. Qualcomm eventually broke off, and Parker Vision accuses them of stealing their technology and developing it. And that's going on right now. So it happens all the time.
And every company's got trade secrets, probably, right? I mean,
yes, as we discussed earlier, the trade secret is just something you wouldn't want your competitor to have, because it gives you an advantage. That could be anything from your vendor list. It could be your pricing, your price sheet. It could be how you organize your construction plans. It could be how you design a building. Anything that you think gives you an advantage and you wouldn't want your competitor to have, that's a trade secret.
What kind of things should you do with your employees to protect your trade secrets?
So that's a great question with your employee, because everything we're talking about, it's always the employee that leaves that steals your trade secret and uses it somewhere else. So you have to make your employees, when they leave, sign acknowledgments that they're not taking any trade secrets. And when you hire them on, you onboard them, you're making them sign employment agreements with you that what you're gonna learn here is gonna be trade secret and it belongs to me. Anything you create belongs to me, the company, and not you, the employee. And so you're just going to paper it up with confidentiality agreements, employment agreements, and then when they leave eventually, or if they leave, with agreements they're not taking any trade secrets with them.
That makes sense. That makes a lot of sense. So before we kind of started the podcast, you and I were just chatting briefly offline, and you did say, and I may have inadvertently gotten into some of these, so sorry about that to the extent any of this is duplicative, but you did say there are kind of like 10 to 12 things every business can do kind of more easily that will help with their IP rights. Do you want to talk about those?
Yeah, Gail, that's a great question. We were in preparing for the podcast today. I sat down and I tried to figure out what are 10 things that any company can do to protect all of its IP, whether that be patents, trademarks, trade secrets, or copyrights. And it's, the first thing you have to do as any company is figure out what you have, right? So you have to conduct an IP audit. What is it that we do as a business? What is it that the processes that we put in place that we do every day when we bring customers in, when we bring clients in? What is it we do? So we had to outline what is our IP, what is it that we can protect? And once you have that universe of IP, that'll give you an inventory for your IP, and then you can start working on protecting it. Once you have that inventory, you can, okay, this trademark I'm going to register. This trademark I'm not going to use. I don't use it right now, so I'm not going to register it. This copyright, I need to file for copyright protection on this. So that allows you then, once you have that inventory, then you go and you can start registering all of your IP. Whether if you have patents, get with a patent attorney to file upon it. We talked about the employment agreements for when you bring on people. That needs to be part of your structure. So non-disclosure agreements within those employment agreements. When employees leave, they have to have other agreements. So you want to put in place agreements, the non-disclosure and employment agreements right at the start, because that'll help you protect your IP. You also, what we talked about a little bit ago, is establishing clear IP policies so that every employee within your firm, within your company, knows what's expected of them when they're working during the day and they make an advancement somewhere. When they change what they're doing, that they're documenting that change, and so that you have the ability later on to add that to your IP list and then register it and further protect it. We talked about this a few minutes ago. You want to educate your employees on IP. You talked about it earlier, Gail, and you said that most of the people you work with don't think they have a lot of IP, but they do. In essence, they all have trademarks, as you said. They all have trade secrets, and they all have material that can be copyrighted. Patents, they probably have a few things here and there. So you want to get someone in to talk to your employees, an expert. Typically, you go to the closest patent law firm and say, hey, can I have someone come to my firm and talk to us about IP rights? And we'd like to use you as a firm, maybe for registering some of our IP assets. And I guarantee you're going to get that patent attorney to come and talk to your employees about what they need to be doing to protect their IP. We talked about a little bit, a big thing is, depending on the type of IP you have, there are different things you have to do to enforce that IP and to protect that IP. So you need to be monitoring the market for infringement. You need to watch out, where are people using my ideas? Where are they not? That'll help you be able to, one, know what's going on in the market, and two, protect your IP so that you can generate revenue from it. In the process of monitoring the market, you're going to have to enforce your IP every now and then. If you don't enforce your IP, what's the purpose in having it? When you enforce it, that means usually getting with the lawyer and filing a lawsuit on it, or at least making the company aware that they're using something that you believe is yours. And that's always, when you enforce your IP, what's that going to do for your company? It's going to lift your company's stature up a little bit. It's going to say, hey, I have IP. I'm a more valuable company because I have IP, and I'm trying to protect it. And you potentially could generate a lot of revenue from a lawsuit as well, which is always beneficial. And being that that's how I earn all my revenue from lawsuits, I'm partial to people filing lawsuits. I mean, the other thing we talked about is trade secrets, protecting those trade secrets, making use of that confidential stamp, making use of locked boxes, making sure that only certain employees know of your trade secrets and that they're signing those employment agreements. Less used, but maybe might be important for some companies. You consider international protection for your patents, international protection for your trademarks, because none of us deal only in the U.S. these days. We always are using our names overseas. So you could register some of your marks in foreign countries if you're using them there. And I guess the last thing, just try to keep the best you can, stay attuned or stay abreast of what the latest developments in IP law are. And you can do that simply by subscribing to an IP bulletin from something like IP Watchdog or a bulletin from the USPTO just to get updates on what the current status is of IP law. And I think with those 10 things that we talked about generally, you can put in place a fairly robust protection program for your IP.
That makes a lot of sense. And look, that sounds like a lot, but it's really not. I mean, most of those things are pretty easy, low-hanging fruit that we should be doing, that I suspect if I polled our listeners, probably about 90 to 95% aren't doing those things. But on the other hand, you hear business owners all the time, including me, say, oh, that's my secret sauce. You know, that I worked forever developing that. So you spent the time, protect it, right?
Exactly. It isn't hard to do. Most of these steps are fairly simple, and most of the initial steps don't cost anything for the company. It's just a matter of documentation. It's just a matter of following the procedure you have in place, protecting it.
That makes a ton of sense. Bill, you have been amazing. I really appreciate your time. But before you go, I have to ask you, what does it mean to you to level up?
Galen, I thank you for that opportunity to be here today. And for me to level up, it's providing representation to the underserved community of IP owners. That's really what my firm strives to do, is to provide the best representation we can to those that are underrepresented and enforcing their IP. That's what it means to me to level up.
I love that. Thank you so much for joining us, Bill.
Thank you very much, Galen.
I'd like to thank Bill Ramey for joining us on the show. Intellectual property can be dry and it can even feel tedious, but if you pay attention and you take it bit by bit, it's really manageable. So here's my challenge to you. Go back, listen to Bill's 10 steps, and actually score yourself like it's a test. I would willing to bet that most of you will get 20% or less. Let's see if we can't get that up closer to 100 so we can actually protect our business, protect our longevity, and make sure that our businesses go on forever. Follow us on Apple, Spotify, or your favorite podcast player.